If you have not read the government's motion to dismiss the criminal information against Michael Flynn, you are missing out on something. But not for long, because that's what we're doing this vlog. Viva Frei, Montreal litigator turned YouTuber, and you may notice that we are not in my usual office, that being my Subaru Ascent. The reason is not because the lockdown has been lifted and the kids are back at school, it is just too hot to film in the car. Even when it's not too hot, the camera oftentimes overheats because it's sitting on the dashboard in direct sunlight, but today it is just too darn hot to do it in the car. My wife and the kids are in the park having a picnic, and I am foregoing the picnic and the sunny weather to bring you this vlog. The Michael Flynn saga is absolutely fascinating. The biggest problem about it is that it's a little too complicated to retain people's level of interest. It's sort of like a variation of the Parkinson's law of mundanity.
Those chips that you bought?
Very spicy chips?
Yeah, they're all dying out there.
Apparently these Aubrey D spicy chips are a little too spicy for the kids. Extra hot.
They're spicy.
Your breath smells like spicy chips. This is sort of like a variation of Parkinson's law of mundanity, except as relates to the news. That which is easy to digest will be readily consumed. That which is more difficult to digest because of its complexity will be less readily consumed. And when it comes to the Michael Flynn situation, most people's understanding is relatively superficial in that they understand that Michael Flynn admitted that he lied to the FBI. He pleaded guilty, therefore the Department of Justice should not drop the charges. When in reality, there is so much more to that story that that level of understanding is no understanding at all. Now, I did a live stream with Robert Barnes where we talked about this in detail. I'm gonna link that video right here. Give it a watch if you have an hour and a half. If you don't have an hour and a half, I also published a 28-minute highlight from that live stream, which is sort of the most important section as relates to the Michael Flynn situation. I'll post a link to that highlight video right here. I'll also post both links in the pinned comment section below. Give them a watch if and when you have the time. Right now, we're going to read through the government's motion to dismiss because it is mind-blowingly fascinating. Now, first things first, because I like to consider my vlogs as unbiased as possible, I should address some points that I know people are going to raise. This motion to dismiss, if it wasn't drafted by, at the very least it was signed off by one Timothy Shea, United States Attorney. Timothy Shea is the interim United States Attorney for the District of Columbia, and he is a political appointee. Also, according to Wikipedia, Shea was a senior counselor to U.S. Attorney William Barr at the Department of Justice. And it was William Barr who named Timothy Shea the interim U.S. Attorney for the District of Columbia on January 30th, 2020, after all of this had already happened to Michael Flynn. Also, according to Wikipedia, so take it for what it's worth, Shea alone signed the court document, an unusual departure as court filings are usually signed by lower-level career prosecutors, not political appointees. Also very important, one of the former prosecutors in the Flynn case, Brandon L. Von Grack, recently withdrew from that file. And so just to describe the one screen, two films, what you are necessarily going to have here are certain people saying that the former prosecutors withdrew from the file in protest, that this motion to drop the charges was drafted by a political appointee and is totally partisan from the get-go, versus the flip side of people saying that this former prosecutor withdrew from the file to save his butt as a result of his own corruption, and now you have the Department of Justice coming in to make sure that justice is served. One screen, two films, but let's read through this motion so you can come to your own conclusions. Government's motion to dismiss the criminal information against the defendant Michael T. Flynn. The United States of America hereby moves to dismiss with prejudice the criminal information filed against Michael T. Flynn pursuant to Federal Rule of Criminal Procedure 48A. The government has determined, pursuant to the principles of federal prosecution and based on an extensive review and careful consideration of the circumstances, that continued prosecution of this case would not serve the interests of justice. Michael Flynn entered a guilty plea, which he has since sought to withdraw, to a single count of making false statements in a January 24, 2017 interview with investigators of the Federal Bureau of Investigation. Now, bear in mind, it is the government that is filing this motion to dismiss. This is the government's position. Although I am sure Flynn and his attorneys agree with this, this is the position put forward by the government to drop the charges against Michael Flynn. Despite the scope and duration of the investigation that brought Michael Flynn in, he was only found guilty of one charge of making one false statement on January 24th, 2017. And as we will see further on in this motion, there is a big asterisk as relates to the tenor of that allegedly false statement. This crime, however, requires a statement to be not simply false, but materially false with respect to a matter under investigation. Materiality is an essential element of the offense. Materiality, moreover, requires more than mere relevance or relatedness to the matter being investigated. It requires probative weight whereby the statement is reasonably likely to influence the tribunal in making a determination required to be made. Why is this relevant? Well, as we're going to see, as relates to the allegedly false statement made by Michael Flynn, it was made with respect to subject matter that the FBI already knew as a fact in that they already had the transcripts on which they were asking Michael Flynn the questions. But we're getting ahead of ourselves, and it's actually described better in the motion than I can describe it myself, so let's just get to it. After a considered review of all the facts and circumstances of this case, including newly discovered and disclosed information appended to the defendant's supplemental pleadings, the government has concluded that the interview of Mr. Flynn was untethered to and unjustified by the FBI's counterintelligence investigation into Mr. Flynn, a no longer justifiably predicated investigation that the FBI had, in the Bureau's own words, prepared to close because it had yielded an absence of any derogatory information. The government is not persuaded that the January 24, 2017 interview was conducted with a legitimate investigative basis, and therefore does not believe Mr. Flynn's statements were material even if untrue. And most notable with respect to that newly discovered evidence were FBI notes which read as follows. Michael Flynn's attorneys made public on Wednesday a handwritten note from Bill Prystap, the then counterintelligence director at the FBI, that mused how agents should approach a critical interview with President Donald Trump's first national security advisor in the White House in January 2017, and gave Flynn's team new reason to cry foul. What's our goal? Truth, admission, or to get him to lie so we can prosecute him or get him fired, Prystap wrote. If we get him to admit to breaking the Logan Act, give facts to DOJ and have them decide. Or if he initially lies, then we present him, redacted, and he admits it, document for DOJ, and let them decide how to address it. In other words, as relates to this January 2017 meeting with the FBI that ultimately led to Flynn lying and pleading guilty, the question was whether or not the FBI in fact set this up for the purposes of entrapping Michael Flynn. Very briefly, the factual background as set out in the motion. The FBI opened a counterintelligence investigation into Mr. Flynn on August 16, 2016, quote, as part of the larger Crossfire Hurricane umbrella investigation into the presidential campaign of Donald J. Trump and its possible coordination with Russian officials to interfere with the 2016 presidential election. In addition to the predication for opening Crossfire Hurricane, which did not specifically identify Mr. Flynn, the FBI predicated the counterintelligence investigation of him on, quote, an articulable factual basis that consisted of 3 facts. Mr. Flynn's service as a foreign policy advisor to the Trump campaign, his publicly documented connection to state-affiliated Russian entities, and the fact that he had traveled to Russia in December 2015. After approximately 4 months of investigation, however, the FBI, quote, determined that Mr. Flynn was no longer a viable candidate as part of the larger Crossfire Hurricane umbrella case, and prepared to close the investigation. Michael Flynn was not part of the original investigation. He only got brought into it in an incidental manner, and after 4 months of investigation, the FBI determined they had nothing on him and were prepared to close the case against him. The FBI had concluded that it was going to close the case against Michael Flynn. If new information became available, they would consider reopening the investigation, but for whatever the reason, they never formally closed the investigation against Michael Flynn. Before the intended case closing took effect, the FBI learned of communications between Mr. Flynn and Russian Ambassador Sergei Kislyak that had taken place in late December 2016, and which touched on matters of foreign policy. By this time, Mr. Flynn had already been named by President-elect Trump as his incoming national security advisor. And this is probably the most critical fact as relates to whether or not Michael Flynn in fact lied and whether or not he would have any impetus to lie. The FBI had in their possession transcripts of the relevant calls. Believing that the counterintelligence investigation of Mr. Flynn was to be closed, FBI leadership, the 7th floor, determined to continue its investigation of Mr. Flynn on the basis of these calls and considered opening a new criminal investigation based solely on a potential violation of the Logan Act. Yet discussions with the Department of Justice resulted in the general view that the Logan Act would be difficult to prosecute. On January 4, 2017, FBI Deputy Assistant Director Peter Strzok learned that Razor's closure had not been timely executed, and the counterintelligence investigation into Mr. Flynn was unexpectedly still formally open. Mr. Strzok immediately relayed the, quote, serendipitously good news to Lisa Page, the special counsel to the FBI Director.
Daddy?
Yep.
Where are you?
I'm here. I may have to go continue this vlog in the car.
Sorry.
So Peter Strzok discovers that the FBI investigation into Michael Flynn is still open despite the fact that it was supposed to be closed. Strzok then relays this serendipitously good news to Lisa Page, and you may recall that Strzok and Page are having an affair together. I say this without judgment. Whatever two consenting adults do among themselves is up to them and them alone, and whatever higher judge may judge them at some point in the future. And Strzok actually messages to Lisa Page, and I'm quoting, "Our utter incompetence actually helps us." Around this time, FBI Director James Comey advised DOJ leadership of its investigation into Mr. Flynn, and senior officials at both the FBI and DOJ had concerns that the incumbent White House officials' descriptions of Mr. Flynn's calls with Kislyak were not accurate. FBI Director Comey took the position that the FBI would not notify the incoming Trump administration of the Flynn-Kislyak communications. Deputy Attorney General Yates and other senior DOJ officials became, quote, frustrated when Director Comey's justifications for withholding the information from the Trump administration repeatedly morphed, vacillating from the potential compromise of a, quote, counterintelligence investigation to the protection of a purportedly, quote, criminal investigation. FBI Director Comey continued to refuse to brief the White House in a subsequent conversation with CIA Director John Brennan. Matters came to a head on January 24, 2017. That morning, Yates contacted Director Comey to demand that the FBI notify the White House of the communications. Director Comey did not initially return her call. When Director Comey called her back later that day, he advised her that the FBI agents were already on their way to the White House to interview Mr. Flynn. Acting Attorney General Yates was, quote, flabbergasted and, quote, dumbfounded, and other senior DOJ officials hit the roof upon hearing of this development, given that, quote, an interview of Flynn should have been coordinated with the DOJ. In any event, that morning, that being January 24, 2017, Deputy Director McCabe called Mr. Flynn to arrange the interview. He explained that recent media statements about his contacts with Mr. Kislyak merited a, quote, sit-down, and expressed the FBI's desire to accomplish the interview quickly, quietly, and discreetly as possible. Deputy Director McCabe further advised that if Mr. Flynn wished to have anyone else at the meeting, including the White House counsel, the FBI would have to elevate the issue to DOJ. Mr. Flynn, himself a former director of the Defense Intelligence Agency, stated that he readily expected that the FBI already knew the contents of his conversations with the ambassador, stating, quote, you listen to everything they say. Mr. Flynn then agreed to meet with the interviewing agents in his office less than 2 hours later. Mr. Flynn was unguarded in the interview and clearly viewed the agents as allies. When interviewing Mr. Flynn, Mr. Stroke and other agents didn't show him the transcript of his calls. Nor did the agents give at any point warnings that making false statements would be a crime. According to the FBI agent's recollections, when asked if Mr. Flynn recalled any conversations in which he encouraged Kislyak not to, quote, escalate the situation in its response to American sanctions, Mr. Flynn responded uncertainly, stating, not really. I don't remember. It wasn't, don't do anything. After the interview, the FBI agents expressed uncertainty as to whether Mr. Flynn had lied. The FBI had decided to end their investigation into Michael Flynn after 4 months because it yielded nothing. If any new information were to come up, they would consider reopening the investigation. But for the FBI's utter incompetence, to quote Peter Strzok himself, they hadn't actually formally closed the investigation into Michael Flynn, so they took the opportunity to set up another meeting. The FBI sets up another meeting with Michael Flynn on short notice, without notifying the responsible people, without allowing Michael Flynn to have an attorney present. They don't give Flynn a copy of the transcripts on which they are asking him questions, even though they have it in their possession. They don't advise him that it's a formal investigation of sorts and that lying would itself be a crime. In light of the equivocal answers provided by Flynn, the FBI is not even certain that he did in fact lie. And on November 30th, 2017, the special counsel's office files criminal charges against Michael Flynn for 1 count of lying. This timeline of events and course of conduct can be interpreted much differently in light of the newly disclosed FBI evidence as to what their intention was of sitting Michael Flynn down for another investigation. That is to say, and I'm quoting again, truth/admission, or to get him to lie so we can prosecute him or get him fired. The newly disclosed, if not newly discovered, evidence were FBI notes setting out that their very goal for sitting down with Michael Flynn might have actually been outright entrapment. Then we have a few paragraphs on the legal standard of the applicable procedure. Federal Rule of Criminal Procedure 48A permits the government, with leave of the court, to dismiss an indictment, information, or complaint. It is also well established that the government may move to dismiss even after a complaint has turned into a conviction because of a guilty plea. The keywords here are with leave of court. That means notwithstanding the motion and the obvious consent from the Flynn team, the judge nonetheless needs to approve of this motion to dismiss the charges. And the government is pointing out that that was a DHL. That was a DHL. We have just done UPS, FedEx, and DHL. All of the ground transport have now gotten their cameos. Well, maybe not all of the ground transport, but you know what I'm saying. The government is pointing out that the judge can grant the motion to dismiss even when there has been a conviction when that conviction was based on a guilty plea, as is the case with Michael Flynn. When the government so moves, the role for courts addressing Rule 48A motions is narrow and circumscribed. Have you heard enough federal rules of procedure for now?
Yeah.
You want to go inside and watch a movie?
Yeah.
Good choice. I'll be back in 2 seconds. All right, and after addressing the legal standard, the motion then goes into the discussion, which is the consideration for which they are asking that which they are asking for. Based on an extensive review of this investigation, including newly discovered and disclosed information attached to the defendant's supplemental pleadings, the government has concluded that continued prosecution of Mr. Flynn would not serve the interests of justice. Proof of a false statement to federal investigators under Section 1001A2 requires more than a lie. It also requires demonstrating that such a statement was, quote, material to the underlying investigation. The materiality threshold thus ensures that misstatements to investigators are criminalized only when linked to the particular subject of their investigation. In the case of Mr. Flynn, the evidence shows his statements were not material material to any viable counterintelligence investigation, or any investigation for that matter, initiated by the FBI. Indeed, the FBI itself had recognized that it lacked sufficient basis to sustain its initial counterintelligence investigation by seeking to close that very investigation without even an interview of Mr. Flynn. With its counterintelligence investigation no longer justifiably predicated, the communications between Mr. Flynn and Mr. Kislyak, the FBI's sole basis for resurrecting the investigation on January 4, 2017, did not warrant either continuing that existing counterintelligence investigation or opening a new criminal investigation. In any event, there was no question at the FBI as to the content of the calls. The FBI had in its possession word-for-word transcripts of the actual communications between Mr. Flynn and Mr. Kislyak. And this is what people really need to appreciate. The FBI came in with an informal, almost friendly meeting with Mr. Flynn, called on short notice with no counsel present, to question him on the contents of a telephone conversation that he had with Kislyak, for which they had a word-for-word transcript of that conversation. And it was on the basis of equivocal answers that Flynn gave in response to questions relating to the contents of a discussion for which the FBI had the actual transcript that they got him to plead guilty to one count of lying to the FBI. As far as I am concerned, it doesn't matter what side of the political spectrum you are aligned with, that should shock everybody's conscience. The frail and shifting justifications for its ongoing probe of Mr. Flynn, as well as the irregular procedure that preceded his interview, suggest that the FBI was eager to interview Mr. Flynn irrespective of any underlying investigation. Deputy Director McCabe effectively discouraged Mr. Flynn from procuring counsel or even notifying the White House counsel. The interviewing agents failed to issue the common Section 1001 admonitions about lying to investigators. Nor did the FBI even notify Acting Attorney General Yates that the interview was happening until the interviewing agents were already en route to Mr. Flynn. Additionally, prior to the interview, there were internal FBI discussions about whether to show Mr. Flynn the transcripts of his calls with Mr. Kislyak. In light of the fact that the FBI already had these transcripts in its possession, Mr. Flynn's answers would have shed no light on whether or what he communicated with Mr. Kislyak. And those issues were immaterial to the no longer justifiably predicated counterintelligence investigation. Similarly, whether Flynn did or, quote, did not recall communications already known to the FBI was assuredly not material. Under these circumstances, the government cannot explain, much less prove to a jury beyond a reasonable doubt, how false statements are material to an investigation that, as explained above, seems to have been undertaken only to elicit those very false statements and thereby criminalize Mr. Flynn. Even if they could be material, the government does not believe it could prove that Mr. Flynn knowingly and willfully made a false statement beyond a reasonable doubt. Mr. Flynn previously pleaded guilty to making false statements. In the government's assessment, however, he did so without full awareness of the circumstances of the newly discovered, disclosed, or declassified information as to the FBI's investigation of him. Mr. Flynn stipulated to the essential element of materiality without cause to dispute it insofar as it concerned not his course of conduct, but rather that of the agency investigating him, and insofar as it had been further illuminated by new information in discovery. Based on a careful assessment of the balance of proof, the equities, and the federal interests served by continued prosecution of false statements that were not material to any bona fide investigation, the government has concluded that the evidence is insufficient to prove its case beyond a reasonable doubt. The government therefore moves to dismiss the criminal information under Rule 48A. And because we know that granting this motion is subject to leave of court, what did the judge in the file do? U.S. District Court Judge Emmett Sullivan disregarded two controlling precedents from higher courts with his decision to appoint John Gleeson as amicus curiae in the U.S. versus Michael Flynn case this week. Amicus curiae is Latin for friend of the court, and it sort of means an impartial advisor who's going to assist the court on a particular case. Judge Sullivan, by way of amicus curiae, has basically invited someone to oppose the government's motion to dismiss the charges against Michael Flynn. And apparently not only is this conduct unheard of, it actually violates a 9-0 Supreme Court decision that was rendered about a week ago. 1 week ago, the U.S. Supreme Court issued a 9-0 decision authored by Justice Ginsburg that took judges to task for similar amicus antics. Her opinion for the court in U.S. versus Sinning Smith upbraided the U.S. Court of Appeals for the Ninth Circuit for violating a basic aspect of legal proceedings called the party presentation principle. In a nutshell, this concept dictates that judges must decide the case as presented by the parties before them. They are not to go out questing for dragons to slay or issues to tackle that the parties have not brought before them. Not only did Judge Sullivan not follow a Supreme Court precedent, but the individual he named as amicus curiae is arguably anti-Trump. Not only did Judge Sullivan disregard Supreme Court precedent, not only did he appoint as amicus curiae someone who is arguably anti-Trump, now he's contemplating whether or not Michael Flynn should be held in contempt for perjury. Some might be of the impression that it's almost as though Judge Sullivan doesn't want this case against Michael Flynn to be dropped. And it does seem from the media and social media that the criticism of Sullivan's actions is relatively bipartisan. Relatively. We'll see where this goes. The entire situation is fascinating, and as soon as there is a judgment on the motion to drop the charges, you know I'm going to be doing a vlog on it. If nothing else, I hope everyone has a better understanding of how Michael Flynn was treated in the context of this investigation. It is absolutely eye-opening. Alright, and with that said, I can see again that my camera is overheating and is going to shut down in 30 seconds. This is part of the problem of doing car vlogs in summer. If you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. It feeds the algorithm. If you want to support the channel, all of the support links are in the pinned comment. We've got merch, I've got Subscribestar, Patreon, and other means of support. But above all else, take care of yourselves, stay safe, stay healthy, go outside, get some sunlight, check in on your neighbors, friends, and family, and now you know your vlog. Peace out.